This is an appeal in the matter of disclosure and barring services and Tata Consultancy Services Ltd.
Yes, Mr. Crowell.
My Lords, as the Court doubtless knows, I appear on behalf of the Disclosure and Barring Service with my learned friends Mr. Carruth and Mr. Mitchell, and my learned friends Mr. Cogley and Levy, King's Counsel, and Mr. Munro appear on behalf of Tata Consultancy Ltd, the respondents to this appeal. The DBS was formed in 2012 from the Criminal Records Bureau and the Independent Safeguarding Authority, and performs two vital functions, perhaps more, but we can categorise them under two headings. I mention this because it's referred to a little bit in the judgment. Barring, which is the maintenance of children and adults barred lists of people unsuitable to engage in regulated activity. That's one category. And the second is disclosure, which is the provision of a service involving providing certification of whether individuals have had criminal records and matters of that side. It's the latter which I think most people may encounter the DBS for. In 2012, Tata Consultancy Ltd agreed to take over the business as usual disclosure and barring processes from the incumbent supplier, but also in parallel to build, design and deliver a modernised system which would replace DBS's previous legacy paper-based systems.
Yeah.
The terms on which TCS agreed to perform that are included in contained in a document, contract dated the 4th of October 2012, and this appeal arises in respect of one of the terms of that contract, as doubtless you know.
Well, you can take it we've read the skeleton arguments.
Of course.
Speaking for myself, I have not read the entirety of the judge's judgment, but I have read the relevant parts which bear on the point under appeal, and I've looked at the various contract clauses again which bear on the appeal.
I'm grateful for that indication. As the Court doubtless knows, the modernisation project was to be undertaken in phases. Phases allied with so-called milestones, with deliverables, and it was common ground at the trial, as the judge records, that TCS would be liable in principle for delay if a milestone date was not hit, subject always to the proposition that it was caused by my client's breach of contract, the so-called authority cause. The regime which governed all of that we see in clauses 5 to 8, but principally 5 to 7 of the main terms of this contract. The contract itself runs to 73 such provisions and has 20 separate schedules. You won't be concerned with almost all of those, though I do want to take you to very specific provisions of Schedule 2.3, but I'll come to those in due course.
Definition schedule.
No, not the definition schedule, my lord. It's a schedule to do with charges, but it's also the schedule that has some provisions relating to delay payments.
Oh, yes. Is that the one that arrived this morning?
It is the one. It's the late arrival, my lord.
Yes.
Just before I turn to looking at the clauses specifically, I just wanted to make three very brief introductory remarks. First is this: the relevant provisions appear to have arisen out of a standard form of contract, in the sense that it arises out of the Model ICT Services Agreement issued by the Office of Government Commerce, and the judge noted that at paragraph 17 of his judgment. We needn't turn this up now, but that's for your note, page 65. However, he also noted that the terms were substantially amended, there was limited, if any, evidence about the reasons for the amendment, and as a consequence, applying authority, he just proceeded in the construction of the contract, applying the ordinary principles without reference to the fact it was a model form. Both parties encouraged that course of action, and I dare say they would do before my lords as well.
So the fact that it originated in a standard form has no significance.
That's what we said, indeed.
Right.
The second proposition is that on any view, the clauses that we're going to be focusing on, 5 to 7, potentially 8 as well, are intended to operate as one coherent regime in relation to delay with regard to this project. I don't know if that's contentious, but that's certainly the approach the judge took. And the third point I make by way of introduction is that there is no basis or evidence to suggest that those provisions were in any way negotiated or concluded separately, or, as we've seen in some cases, the work of many different hands. I mention that only because I'm conscious that my learned friends have asked for an authority to go into the bundle, which bears on the question of, if it is that such a thing, do the ordinary principles not apply so much? I'm not going to deal with that in my submissions. I'll pick it up in reply, but I make that point just by way of introduction now. Now, with those introductory words, can I invite the court to look at the relevant provisions? I'm going to make that invitation in the actual contract itself, because although they appear in various different places, obviously the complete form is in the contract, and that's behind tab 15 of the core Bible, starting at page 554. Although this appeal relates to clause 6, it is, in our submission, important to see the regime as a whole. So clause 5.1 is a provision which imposes upon the contractor, that's TCS, the respondents, an obligation when it becomes aware that it will not achieve a milestone by the relevant milestone date, as soon as reasonably practical, to notify the authority, my clients, and summarise the reasons. And then at 5.2 over the page, my lords, there's an obligation within 5 working days thereafter to provide what's called an exception report. It's actually strictly a draft exception report. And at 5.3, we see what that is, what that must include, full details in writing of reasons for delay, actions being taken to avoid to mitigate delay, and the consequences of the delay. Now, I draw attention to that for 2 separate reasons. The first reason is this: there's already a regime under the contract whereby the contractor, Tata Consultancy, are obliged, in many cases before a milestone date has not yet been reached, but they become aware that it won't be met, to provide to my clients details, initially a summary of the reasons, that's the initial notification, and then within 5 working days, details of reasons, actions being taken, consequences. So when we look at the operation of the clause that we're concerned with, clause 6, important to bear in mind that it has to be read as part of this scheme where this obligation already exists. The second point I make in relation to this is to contrast relatively specific obligations and detail of what's required of the contractor in this context with what we'll see in clause 6. And the significance of that arises when we turn over the page at 556 to look at clause 5.6.
The double reference to 5.3 is presumably error.
Yeah, I believe so.
5.1, 5.2 and 5.3. Right.
That must be right.
Right. So if the, is this right? If the contractor gives notification under clause 5.1 but doesn't do it as soon as reasonably practicable, then DBS is not liable.
Well,
is that right?
It certainly appears that DBS is not liable if you don't have compliance with 5.1, 5.2 and 5.3.
Yes, and 5.1 requires something to be done as soon as reasonably practicable.
It does.
So if it's not done as soon as reasonably practicable, DBS is off the hook.
Well,
is that right?
I'm not avoiding the question. Yes, to the extent that this clause allows them to be off the hook. That is the sense that the obligation, so 5.6 relates solely to an obligation to compensate. We will see when we look at clause 7 that there are various remedies and reliefs that the contractor is entitled to which is not excluded by 5.6. It is limited to the obligation to compensate. But to that extent, non-compliance with 5.1, 5.2 and 5.3, any of these would be sufficient. And I take my Lord's point, I understand where my Lord's point's going. I understand the significance of it in the context of other submissions we make, but I'll come back to that if I may.
Right.
But the what I say about 5.6, which is we say telling, is that 5.6 is expressed as a clear and freestanding provision, which makes clear in a way that there's no room for any doubt what the consequence of TCS's failure to comply with the provisions are. No need to write it in, no need to work it out, no need to make any implications. It couldn't really be set out more clearly here.
Although it was one of the issues before the judge.
It was one of the issues before the judge.
Well, the judge, as part of his huge task, had to decide that point.
Well,
both of these, as I understand it, both of these conditions precedent were up for grabs.
Well, I don't believe there was any dispute from my learned friend's side that 5.6 gave rise to a condition precedent. The debate was about the effect of that, the scope of it, rather than whether it was a condition precedent. I don't believe, I'll be corrected if I'm wrong, but I don't believe there was any argument about whether that it is a condition precedent.
So you say the argument was all about the effect of the clauses?
Correct. So the argument was about what does a right to compensate mean? What's the impact of that? And the like. And there was also a different debate about whether, and you may have picked up if you, depending on how much the judgment you've read, whether there was an estoppel by convention, which meant that non-compliance, in the end, was without the consequence it would ordinarily have. But those were the debates in relation to 5.6. We say 5.6 is clearly a condition precedent, and the parties are expressing it. And it's important to understand, not simply are they using language here which is very clear, but they're also doing it by reference to obligations, which themselves, we say, are clear. I take my Lord Justice Lewison's point about as soon as reasonably practicable, but there is clarity as to what's required in 5.2 and 5.3 and even in 5.1. And we'll come to see whether you have the same clarity in 6. And just reading on from this, it's worth just bearing in mind 5.8. There's an obligation upon the TCS, and this is a subsequent obligation. Effectively 3 days after the service of the draft exception report, that was 5 working days from the notice. 3 days later, they have to serve a draft correction plan, and we see the details that need to be in a draft correction plan in 5.8. It's supposed to be submitted when it becomes aware it will not achieve. And we can see at 5.9, draft correction plan identify the issues arising out of delay and the steps the contractor proposes to take to achieve the milestone in accordance with the agreement. And 5.10, as soon as possible, and in any event not later than 8 working days, such other periods may be agreed after the initial notification. That's the 5.1. So the scheme is notice as soon as reasonably practical, exception report 5 working days, correction plan 8 working days. And it is perfectly possible to envisage scenarios when all of those things ought to be performed before the milestone date itself has even come, even arrived. So it's with those observations about clause 5, let's invite the court to turn to clause 6, which is at 558. We can see from clause 6, I'm sure the court's read this in lots of different places because it's been considered in lots of different places, that the provision of clause 6.1 is said to amount to a condition precedent. It starts with if, and some significance is attached to that, particularly by the judge, and I'll come to that if I may. The if that it specifically attaches to is the non-satisfaction of either an acceptance test success criteria and or non-achievement of a milestone. And then after that we have a comma, then it says the authority shall promptly issue a non-conformance report. And then it tells us something about what a non-conformance report might address, should address. And we can see, because just while we're here, it's categorizing test issues, testing procedures. So those are testing issues. So in a world where testing is not the problem, it's simply the missing of a milestone, one simply has the setting out in detail the non-conformities of deliverable when no other testing has taken place, including any other reasons for the relevant milestone not being achieved and the consequential impact on any other milestones. So that's what a non-conformance report is meant to do. And then the sentence at the end that the judge invested significant detail, significant relevance to, the authority will then have the options set out in clause 6.2. Now, I draw attention to a number of features. I'm going to develop my submissions in due course, but first of all, there's only the one if at the start of the 6.1. There's no if immediately before the authority shall promptly issue. So if has a significance, that's worth bearing in mind. One has to read it that way. It's not been expressly put that way. And the comma itself isn't naturally necessarily an if. It could be just as happily a then. In that event, you do this, not if you do that. So in that sense, the reading of the second part of the clause as being an if requires that construction of it. And I'll come back to why that may or may not be legitimate. The second observation I make is that in the context, so this clause operates in at least two obvious contexts. One where there has been a test failure, and one can see then in those circumstances why the provision of a report identifying the precise nature of the test failures may be of utility. But it also has to operate in a world where all that has happened is a milestone has not been met. Effectively, the date when something should have done has come and gone. And in those circumstances, it's still, on the face of it, necessary to serve an exception report. Well, the content of such a document, however, needs to be reflected on, given the terms we've looked at in clause 5. This is a document that presumably would be provided in many cases after the contractor has already provided notification that it will be delayed and a milestone will not be met, has provided the reasons for that, and if we've got to that stage, identified what the consequences are, that's in a draft exception report, and even what it's going to do to put matters right, a correction plan. So it's not entirely obvious in that context, where one looks at the operation of this provision when simply a milestone has been missed, which were the facts of our case, precisely what the exception report is telling the contractor, which the contractor hasn't already, it's already under obligation to tell DBS. I see it may have a role, and we accept it may have a role in the test failure context, although that may or may not have been covered by the matters in clause 5, but it is relevant when considering the weight you give to these provisions to bear in mind just precisely how this would operate, whether it would appear to be something of great importance, and
Sorry, under 6.1, I understand the point about non-satisfaction of an acceptance test success criteria, but the second limb is the milestone is not achieved due to the contractor's default.
indeed.
So it's not just because a milestone isn't achieved, it's because it's due to the contractor's default. And it does then trigger not only a non-conformance report, but also triggers a draft correction plan.
Well, my lord, the judge in his judgment held that
Well, I mean, it does, because 5.10 says so.
on 5.10, the draft correction plan is triggered by reason of the obligations under clause 5.
It says, last words, or the issue of a non-conformance report. A non-conformance report is only, so if you don't achieve a milestone due to contractor's default, you have a non-conformance report issued by the contractor, who presumably knows why they're, or is expected to know why they're in default, and they issue a draft correction plan as to how to put it right.
Well,
I was failing to understand the point you were making against that background.
okay, my lord, I'm making, there are 2 points really. First of all, that a non-conformance report is something my clients issue. It's an exception report that the contractor issues. So in terms of nomenclature, just to be clear,
No, quite. That's the point my lord's making.
I believe it is, but I just wanted to be, the way he put the point, I just wanted to be clear that that's the point he was making.
I mean, the point that's being put to you is that if DBS issues a non-conformance report under clause 6.1, then 5.10 requires a contractor to produce a correction plan.
Yeah, so in the event that my clients issue a...
Sorry, I may have I may have run the two together. I think it may have caused the confusion, so I'm grateful. Yeah.
No, it's but the point is an important point in any event, and it's the point my Lord Justice Lewison puts to me. It's quite right that an obligation to issue a correction plan can arise if my clients, in the context of this contract, issue a non-conformance report. I recognise that. But equally, my point is there can equally be a freestanding obligation to do it, even if we haven't done it. And that's the point I make. I recognise that it can trigger it, but one needs to test all of this, all of the way in which the regime works in all scenarios, not just some of them. So it's important to see that there are scenarios in my submission where nothing would be done on my side and a correction report would be required. But it's perfectly clear, however, that if a non-conformance report is issued, a correction plan is then required. And I don't dispute that, but I don't say that undercuts the point, the more general point I'm making. The point about default, my lord, this was a point that was put before the judge, and the judge decided whether default meant something more than simply being late. And he concluded it didn't. Being late is default. And if we need to just look at it in the judgment, it's at paragraph 83 of the judgment.
It's just before we go to the judgment, is
Sure.
contractor's default with a capital D defined somewhere?
No. I don't think contractor's default is. Default is.
Default is.
Default is. But not contractor's default.
Well, okay. Well,
But in his...
There's a whole load of the judgment about authority cause and contractor default.
Yes, so it's just so it's clear what the passage.
Always good in a contract that takes up a whole file. The key terms have to be decided by a judge because the definitions didn't extend that far. But we understand, Mr. Crowley, your submission is all terribly clear.
I'm grateful, my lord. So, page in the judgment itself, what I have in mind is paragraph 83, which is at page 89 of the full bundle. Paragraph 83, the judge expressly deals with the significance of the expression contractor default.
Yeah.
And he concludes that nothing in addition to missing a milestone is necessary for there to be a contractor's default. It's against that backdrop that I make the submission I did, my lord, that in the context
Sorry,
of...
so could we just,
Yeah.
Do we just strike the words due to the contractor's default out of the contract?
Well,
Because you just say it just means if a milestone isn't achieved.
no, my lord, because I don't think I think that would be too simple, because there are scenarios where where clause 6.1 would apply, where there may be a default as opposed to simply a freestanding separate default, as opposed to simply missing your date. So 6.1 has application in other circumstances other than simply missing the milestone date. So it has a wider application than that. For example, if there's a default in a deliverable gives rise to a testing problem, well then the contractor's default, and you might want to identify some other form of default.
I'm just maybe not just keeping up with this. I thought you showed us paragraph 83 to say that, to indicate that the judge had said that simply missing the milestone is itself a breach, and therefore there was no significance to be attached to the words due to the contractor's default. Did I misunderstood that?
In the context of missing a milestone, there is no additional significance to the word default.
Right, well that's the only,
That's-
those are the only words. Well, sorry, are you saying that the words due to the contractor's default also apply to if a deliverable does not satisfy an acceptance test success criteria? Because they're separated by the words and or.
It's the word "and" that it occurs to me that there may be a world in which a contractor, one might be relying upon a contractor's default other than simply being late. If you are,
Well, wait a minute. How does that work? Let us suppose that the deliverable does satisfy the acceptance test success criteria. And let us suppose that the milestone is achieved. Where is there room for contractor's default?
well, there wouldn't be in those circumstances.
So
In those circumstances, we wouldn't be within clause 6.1.
no. But you say that not achieving the milestone is of itself contractor's default.
Indeed.
Is failure to satisfy the acceptance test criteria enough of itself?
Well, that would be that is capable of being a contractor's default, whether it's a
Capable of, but may not be.
It may not be.
So where is this wider meaning you're attaching to contractor's default?
I don't attach a wider meaning to it. The point I make, really, for present purposes, is this: if one asks oneself the question, what is the utility of the exception report? In the context of missing a milestone, my submission is it's hard to put your finger on what its great utility is. It is sufficient, on the face of it, for my clients to simply say to my own friends' clients, "You've missed your milestone," because that has wrapped within it it's exactly the scenario that we're in, and it's a contractor's default. All I'm doing is not precluding the possibility that there are other scenarios out there where default may have a role. But in the scenario that we're concerned with, it's my submission that there's nothing more that that my clients would need to say. And in a sense, they'd be telling TCS in those circumstances what they already know.
But if, I don't quite follow this, if something is due to contractor's default, then that something has to be a consequence, doesn't it, of contractor's default?
In the sense of missing a milestone, it's the delayed progress which gave rise to contractor missing the milestone.
But the only things that are mentioned in clause 6.1, which are said to be due to contractor's default, are either failure to meet the acceptance test criteria or failure to achieve a milestone. So I'm at a loss to see where you get some sort of freestanding contractor's default which is not caused by one or other or both of the preceding things mentioned in clause 6.1.
So it's not my submission that there is some freestanding. I was focusing on I'm conscious that it operates in more than one scenario. We're concerned with the milestone scenario, but this is concerned really with a testing or a missing of the milestones. And it tells us what you need to say, and the judge has made clear that on the face of it, he's held, there's no challenge to that missing the milestone is itself a contractor's default, in which case the submission is there's nothing really nothing of moment that would be set out in an exception report.
Is that right? Just take as an example, the report has to identify the consequential impact on any other milestones. Those of us that have spent far too long of our working lives dealing with delay claims know how important that is. That's much more than just saying you missed a milestone.
Now, I recognise that, but I follow that. But as the judge recognised, you can only be required to say what you know, and the reality and the way I put the point is twofold. I see my lord's point. The first is that much of this information, if the scheme of the contract operates, is already being provided to us by the contractor. And secondly, as the judge recognised, to the extent that we have independent knowledge, which allows us to say, well, this will be the consequence, well, I see that would have to be set out in an exception report. But whether we would have independent knowledge that this is the impact on the other milestones would depend on all the circumstances. So there are scenarios in which all we could realistically say, or all we could usefully say, either because it's already been said, because of the clause 5 regime.
I think clause 5 deals with the impact on other milestones.
Clause 5 deals with consequences. So 5.3.3, page 5.5, the consequences of the delay.
5.3.3.
The consequences of delay.
Yeah.
I recognise that that's not as explicit, but it would nevertheless be the kind of thing that would allow somebody to form a view on the whether other milestones are being affected. But for present purposes, my point is quite a narrow one. It's simply that there are scenarios, which ours is one, where there's a limited amount that an exception report can tell the contractor, and certainly can tell them that they don't already know. Not only don't already know, but they haven't already been obliged to tell us. And just while we were looking at how the judge dealt with this, the judge dealt with this point, and it's at paragraph 87 of his judgment, page 90. And for present purposes, I'm interested in really his conclusion at the final sentence. Whilst the non-conformance report would be limited matters were properly within our knowledge, improbable that a non-conformance report which simply says not achieve a milestone would comply with the requirements of the clause. And for the purposes of this appeal, the significance of that, my lords, we say, is that my lord, the judge, said it's improbable, but he left somewhat unclear precisely what it would be a compliant exception report. Left unclear what would be required to meet the requirements.
What the clause requires, including any other reasons for the relevant milestone not being achieved and the consequential impact on any other milestone.
If one, but my lord, if one doesn't know those
he's
matters,
entitled to say, isn't he? If you just said you've not achieved the milestone by the milestone date, that wouldn't be, on the face of it, complying with clause 6.1.
but if one didn't have knowledge of those other matters,
Well, that would then be a matter of fact.
well, it would, my lord. But if
You would promptly issue your NCR saying that and we don't know anything else.
and in which case you were effectively doing the same thing, aren't you, my lord? But what? So yeah.
But I mean, all the judge is doing is comparing your submission with what clause 6.1 says.
And I follow that. And the significance of this is simply where this goes to is a submission that I'll develop in due course to say that in the context of this contract, two things. First of all, it's not easy to see how in certainly some circumstances an exception report should be the kind of thing which the parties would have agreed would be would effectively be a condition to all of the options we see at 6.2. But the second element is there is, at least in some scenarios, uncertainty as to precisely what's required on our part to comply. And that's a factor that weighs against a provision being a condition precedent. So that's where the submission is going, if that helps. If I may, I was going to look at 6.2. Now, 6.2 sets out the options which, at the authority's discretion, it may exercise. The one we are directly concerned with is the one we see at 559, 6.2.3, require the payment of delay payments.
How does 6.2.1 work without the non-conformance report?
How does it work without it?
Yes.
Well,
Test issues have to be specified in the non-conformance report. If there's no testing, then there has to be an agreed correction plan. That's the plan under 5.10, which may be issued on when DBS issues its non-conformance report. So without a non-conformance report, how does 6.2.1 work?
well,
How do you know what the test issues are unless you've got the non-conformance report?
Well, my lord, I recognise, I entirely recognise that in the world of test issues, one can see that for test issue purposes, you need to know what the non-conformities are. And a principal place where you find that out from is the non-conformance report.
Yeah.
So I fully recognise that 6.2.1 is something which proceeds on the basis that we will comply with our obligation to provide.
6.2.2.
And there's no doubt we have such an obligation. The issue is whether it's a condition precedent.
6.2.2 is the same.
Indeed, it's the same point is good for 6.2.2 in that these are provisions that are really directed at test failures
Yes.
and the consequences of them.
Yes. So if you need the non-conformance report before DBS can exercise options 6.2.1 or 6.2.2, why should it be any different for 6.2.3, bearing in mind that DBS, as I read the clause, can combine two or more of these options?
Well, my lord, the 6.1 applies to more than one scenario. We've been over that. If you're in a world of simply failing to meet the milestone, you aren't in a space where 6.2.1 or 6.2.2 apply. And the question then arises is, our obligations, because no one disputes we have an obligation to serve an exception as a non-conformance report. The issue is whether it's a precondition to relief to the options under 6.2.
If you can't operate 6.2.1 without a non-conformance report, how can it not be a condition precedent?
Well, it
In
may
other
be
words, that option can't be triggered unless you've got the non-conformance report.
Well,
This
no.
is, I don't understand.
Well, my lord, it's perfectly possible that the information required to identify what didn't conform and what the issue is has been provided, for example, in an exception report. It's perfectly possible that that information is provided by some other means. So I recognise that the non-conformance report in 6.1 has, and I think I said so earlier, has a clear utility in the non-testing cases. And it has a utility, and that utility it means that one can see how that utility feeds into 6.2.1 and 2.2, and I don't seek to push back on what my Lord suggests to me.
So do you accept that 6.2.1 and 6.2.2 are dependent on an NCR, and therefore without an NCR those options aren't open? So for those options it is a condition precedent.
I don't accept it's a condition precedent.
Well, so what do you mean by a condition precedent?
What?
Are you talking about the service of an NCR at all, or the service of an NCR promptly? Because there are two potentially different points wrapped in there. Now, on the facts, we are told you didn't serve an NCR at all.
That's right, but equally no exception reports were served. The facts were peculiar in that sense, in that neither party complied, because I won't get into the facts because it's not helpful to do that. But the world way in which it operated is these notice provisions were just not operated by the parties, or at least not strictly complied with by the parties. And that was a two-way street. And that's perhaps how we get to be where we are. So no NCRs were served by us on the facts, and that is correct. But that might be and I see that. The difference here really is a difference between saying, and we'll see this in the cases I'll come to shortly, that you can have an independent obligation, the breach of which can mean that the next step somebody has to take is harder and more expensive and they can claim in damages. But the fact that it can be an independent obligation as opposed to a condition precedent. And the question here, for my lords in this court, is whether the provision of a non-conformance report is a condition precedent as opposed to an independent obligation. And we recognise that there is a world where, in our case, it's an independent obligation. Our case, we recognise there is a world where which, if we fail to comply with that may, for example, make the contractor's life harder, and that may well, in theory, sound in damages if as a consequence they suffer loss. And we see hints of that kind of analysis in the Scottish Power case with Mr. Justice Leggett, as he then was, analysing clauses in that way. But we do say that in order for something to become a condition precedent, it's not enough that the information is useful. It is necessary for the parties to make clear with their language that that's precisely what they're intending to achieve. So we do say that the context is important. We say, in terms of the information required, the underlying context and what would be provided in any event under Clause 5 is important. But I do recognise that 6.2.1 is, and 6.2.2 proceed on the basis that information about test issues will be provided, and the obvious place for that to be provided is, of course, the NCR.
If the contract provides for two steps to be taken, you can't take step two unless you've taken step one. Step one is a condition precedent, isn't it?
Well,
I mean, we may be getting too hung up on labels to condition on what is a condition precedent. But if there are two steps in a contract, you can't take step two unless you've taken step one. I would have thought, and correct me if this is wrong, that step one is a condition precedent to step two.
Well, I see what my lord puts. I want to reflect on whether that means it's necessarily a condition precedent in the sense that matters for these purposes, which is to say, you simply can't operate step two at all. Any entitlement in relation to step two is you're deprived of until step one has taken place, as opposed to an obligation which, if you don't perform, may make step two harder, and then you have an independent claim for damages if you need to. And I say that's of relevance here in a context of a dispute where there are there is reason to believe that the kind of information that would be required, for example, to produce a correction plan, would be something that may well be provided by different means in any event. And I've shown you clause 5 and how that may come to be. But there is a broader point which I think I need to take up with my lords, and that's the proposition that,
Can I just ask you?
of course, my lord.
a follow-up? Under 6.2.3, it deals with delay payments, and at the end it talks about delay payments accruing on a daily basis until the milestone is achieved in accordance with the correction plan. How would the correction plan have been issued unless a non-conformance report is issued?
It would be issued, my lord, under clause 5.8. There's an obligation to submit a draft correction, that's right, page 556.
So,
There's an obligation to do a draft correction plan as soon as the contractor becomes aware that it will not achieve a milestone. 5.9 tells you what the correction plan identifies. And then 5.10 tells you that it must be served for approval within eight working days of either the initial notification of 5.1 or the non-conformance report. So a correction plan can come into existence without there ever having been a non-conformance report, because there's an obligation to produce one. In the circumstances I've identified, or the contract identifies at 5.8. So a correction plan has a freestanding life absent a non-conformance report. It's simply all that 5.10 is saying is that if you haven't served a notice under 5.1, well then there's another way in which a correction plan may become required, and that's if your contractual counterparty, DBS, have served a non-conformance report. I hope that answers my lord's question.
thank you.
And the point I was going to make, really in response to the court's observations, is that if, as you have here, you have 3 options that arise under 6.2, and one could say, as has been suggested to me, that one can seize how a non-conformance report may be of moment for option 1 and option 2, it doesn't follow that it should be of moment for option 3. If you can look down a list of things that have to be complied with or consequences, and they're quite different, and some are inconsistent with it being a condition precedent. There's no reason in principle why a non-conformance report should have any impact on the right to delay payments, other than, unless the parties have obviously and clearly so agreed, well then that's a reason that would weigh against 6.1 being a condition precedent. I'll show you some authorities that say that when you've got some that look like candidates and some that don't, that's a point against a clause being treated as that, because it's got to work for all of them. 6.3 is just worth dwelling on for a moment. And the significance of 6.3 is it provides that delay payments are the sole financial remedy for delay, save for specified circumstances. And the significance of that, my lords, is that what this clause is in effect doing is it's depriving my clients, at least for the first 6 months, which is one of the exceptions, of its right to common law damages. If it's deprived of delay payments, well, it's deprived of a right to damages at common law. And that squarely puts us into what I'll call, by way of shorthand, Gilbert Ash territory. And then, if I may, I just wanted to show you also just a passage at clause 7.1. This is where one sees the position as set out in the event that you're in the world of authority cause. But the significance for present purposes is the opening line, without prejudice to clause 5.4 and subject to clause 5.6. So we can see there that the draftsman has gone out of his way, or her way, to spell out that what follows from there is subject to 5.6. And you'll remember 5.6 is the provision that made it a condition precedent for the obtaining of compensation that 5.1, 2 and 3 were complied with. So specific language being used there, and we see no equivalent language in 6.1 or something of that kind. No subject tos or something like that. The only other point that arises out of clause 7, my lords, page 561, is one can see that if you're in clause 7, the contractor is then entitled to certain things under clause 7.2. The authority must do some things under 7.3, and then at 7.4 there is the right to compensation. And what 5.6 does is, as the judge held, and I think was common ground, and if it wasn't, it was soon resolved at the hearing. 5.6 deprives non-compliance with 5.1.2.3 deprives the contractor of its 7.4 right to compensation, but does not deprive the contractor of the other things which flow. For example, being entitled to an extension of time, not being in breach of the agreement, having no liability for delay payment. So that's 7.2. All of those things.
So the shield survives, but the sword doesn't.
In effect, that's right. Whereas we contrast that with the situation under clause 6.1 and 6.2, where, as we can see, on the judge's construction, and he accepts this, all elements fall away, not simply the compensatory element.
But the bottom line remains the same. Neither side recover money.
If one, indeed, it has an impact on.
Because you don't get their liquidated damages, if that's what they are, and they don't get their loss and expense.
That's right. That's right. But
they do get an extension of time,
yes,
which would protect them against the liquidated damages that, because of clause 6.1, the judge found you can't levy.
Correct. That's all correct. But on the other hand, my point really at these, this goes just to the judge's point about symmetry. The judge said that in effect, his approach was justified by saying that there was a symmetry between the way in which clause 5.6 operated and clause 6.1 as he construed it operated, and we say that there isn't symmetry in the same way. It's perfectly true, as my Lord Justice Coulson points out, that the financial claims are both parties deprived of it, but we're also deprived of other things under 6.2, whereas it's simply financial under 5.6. Now, I was going to show my lords some case law. I'll do that. I suspect some of this is familiar, in which case I'll take it as quickly as I can. But just before we get there, just really, I'm sure my lords have this in mind. You'll be aware that the judge held that just in excess of £1.59 million worth of delay payments would in fact have been payable, and the judge held, as he did, as the meaning of 6.1. He also set out the general principles of construction, which I wasn't going to take my lords to because they will be very familiar, but they're there if you need reminder in the judgment, And also an extract from Triple Point Technology, which I also wasn't going to take my lords to, but it's there in the judgment if you need a reminder of it. I was going to focus on some case law relating to conditions precedent specifically. And
there's not a huge amount of utility, is there, in looking at case law on this kind of question?
Well,
This is a question of interpretation of this particular contract and how judges have interpreted different contracts, particularly those where you need a notice to rely on a force majeure clause, are of limited help, aren't they?
I would accept the point being put to me that looking at contracts on a slightly different form and looking what the outcome is of limited utility. What I hope to be of utility to the court is to derive some statements of principle which are of relevant to the way in which my submission the court should approach the matter. Can I tell you what those statements are?
Yes.
And then show you the cases which I say support that. Some of these I suspect would be uncontentious. To create a condition precedent, this is my first, the language must clearly signal the necessary element of conditionality. There is no requirement for the use of a language such as condition precedent or provided always or subject to, although it may be relevant if those words are not used and could have been used. That's my first proposition.
Yeah.
The second proposition is where the draftsman of a document uses a different language or different formulation in a related part of the same contract, it is to be presumed that the draftsman's meant something different by using a different formulation. In the context of condition precedent, I'll show you a case, at least one case, two cases, where this court has given significance to the fact that a condition precedent was formulated clearly in one clause, which weighed against it another clause being a condition precedent. The third proposition is that clauses starting with the word if, which identify as part of what follows an obligation to be fulfilled, can, in appropriate circumstances, and if appropriate language is used, amount to a condition precedent. But the context or language must be clear. And the use of the word if, or synonyms for if, at the beginning of a provision, even with a then at the after of it, does not lead inevitably, or even on a presumption of a condition precedent.
Why do you, sorry, what? I wasn't quite sure what you said. You said, but the context or language must be clear.
Yes.
Well, two questions. The context must be clear. I mean, are you saying that you don't get a condition precedent unless the language is clear?
Indeed, but I am saying that, but I recognise that.
So are you saying there's a sort of presumption against a condition precedent unless you have clear language?
Correct, but I recognise that construction is a unitary exercise. You look at language, you look at the language used, and it's legitimate to look at purpose and context. And sometimes language, in some scenarios, wouldn't do it, may do it in a different situation if the context demonstrates the conditionality with enough clarity.
Is there a better way of indicating conditionality than the use of the word if?
Yes. Well, it depends what you mean by adequate conditionality. There are clearer
The
ways.
natural meaning of if is that whatever the if clause governs has to be satisfied before the consequences flow. I mean, there are rhetorical, grammatical names for all that, and the one is called the protasis and the other one's called the apodosis, but we needn't worry too much about that. But that's, I mean, even as a matter of logic, never mind language, if then is an expression of a conditionality.
Oh, it certainly provides some form of conditionality. That's
Yes,
definitely.
that's why I don't really understand where your first proposition is going to get us, because if then is a classic example of expressing a condition followed by a consequence.
Well,
The question is, what is governed in this clause by the word if?
which is why I recognise that indeed, and has sufficient clarity been provided as to the consequence of non-compliance. Those are really the questions. I recognise that, which is why I recognise that if can be. I'm not saying if can't be, and it'd probably be a foolish submission to say any formulation can't be, but I recognise that if is a word which has conditionality, and therefore in the right circumstances it can do the job.
I think the point, it's the combination of if then. I mean, I understand those words appear in two separate sentences, but it's the if followed by the then at some remove, is what I think is the high watermark, if you like, of the case in this respect that you're facing.
Indeed. But
Okay, sorry.
I promise I'll come back to it when I.
You say we start. Is this right? I think you are saying that you start with an assumption you don't have a condition precedent unless the language is clear. And I'm just thinking, why do you start with any sort of assumption? You just say, well, what does it mean?
Well, in a sense, what does it mean, and is the language being clear, are different ways of formulating the same question. I'm not necessarily suggesting there's some different test. It's just what we've seen, what the cases show, and Triple Point would support this in a situation where a party is being deprived of its common law rights for non-compliance, is one needs clear language if one's going to proceed on the basis that a party has given up its legal rights. But if the clear language is there, it works. But you need
That's a separate point there, isn't it? The giving up the common law rights is the function of clause 7.
No, it's the function of clause 6.3, my lord. It's the function of my clients being deprived of any claim for damages other than a delay payment for breach of contract.
But isn't that a little artificial language when you're talking about a liquidated damages clause? For most employers, a liquidated damages clause is heaven sent compared to their common law rights, because it's a fixed amount that they get subject to the procedural issues that they get irrespective of being able to prove loss.
I follow that.
So giving up may overstate it. It's simply the way in which, for most construction and infrastructure and IT and most long ongoing projects have liquidated damages provisions because they're seen as being better. I
don't dispute any of the matters my lord puts to me. The proposition I put is simply that the effect of clause 6.3 is to say, even though there's a breach of contract, there are, if you do not comply with the obligation to produce a non-conformance report on the judge's construction, you don't, not only do you not get delay payments, you get nothing.
Yeah, sure.
And that in effect deprives you of what would otherwise be a right to claim damages. So it is operating as more than, if it wasn't an exclusive remedy, this point wouldn't be open to me, but it is for those 6 months. So the consequence is the effect of, according to the judge's construction, no NCR, you don't need, my learned friends' clients can breach the contract with no consequences. And that's the kind of thing that requires clear language. I'm just dealing with my learned, my Lord, or Justice Snowden's point. I recognise that clear language and reading it is all part, but it's just that what the authorities say. Fourth proposition, the absence of a precise time limit for performance or lack of precision as to how the alleged precondition is to be fulfilled militates strongly against the requirement of a condition precedent.
And you're saying that, are you, to focus our attention on the word promptly?
I am. And the
Just pause a minute on how the condition is to be fulfilled. You're talking, are you, about the contents of a non-conformance report? Is that what you're getting at there?
yes, and
Because we know, don't we, from experience, that there are a multitude of disputes under share purchase agreements about what the notification of a warranty claim must contain. I mean, they come before the courts, I wouldn't say every day, but frequently. And that has never stopped a court saying that compliance with the notice requirements under a share purchase agreement is a condition precedent to making a warranty claim. Now, it's true that in most of those cases there is a time limit for doing it, a fixed time limit for doing it, but just concentrating for the moment on the contents of the notification, that doesn't seem to deter anybody from saying it's a condition precedent.
all of these things, all of these submissions, and I recognise they're factors. They aren't decisive.
Yeah.
So if a court is satisfied that it has the clarity of language, enough precision, a court may say, well, would have been better, but it doesn't stop it being a condition precedent. So, so I don't suggest any of these things are clinchers, but it's a question of where you weigh them in the balance. And I recognise that one find cases on either side of that line. Back to my Lord's point that how useful are those when you're construing a different contract? The fifth proposition, or my final proposition, is the fact that the consequence of non-compliance may be important or may be trivial militates against the requirement being a condition precedent.
This is right. Putting it another way, you're saying that if it sort of becomes almost happenstance as to what the consequences are, as to what the breach of the clause is, or what the non-compliance with the clause is, that means you shouldn't construe it as a
Condition.
whole thing as a condition
If
precedent.
there are circumstances in which non-compliance has no great or material effect, there may be other circumstances in which it does, but if it could be either, so say the cases, that's militates against. Again, I don't say it's a clincher. I'm wrong to describe any of these things as clinchers, they're factors.
And you're treating, in this respect, you're treating this clause as indivisible. It's either a condition precedent in whole or it's none at all. I mean, in other words, putting more specifically, is it possible to read this clause that failure to provide a non-conformance report just means that you can't operate 6.2 at all and you lose it, you lose your rights as a consequence because the authority just hasn't provided the report? That is a condition precedent to the clause operating. But but the requirement to do so promptly may not be a condition precedent because it's of less importance and it's a little vaguer, and it would give rise to greater arguments or create a tripwire for the authority that if it didn't do it so promptly, it would be argued it loses its rights. So that is it possible to read this clause as containing a condition precedent in relation to the actual issue of a non-compliance report, but not a condition precedent in relation to the timing of it?
My Lord, I would submit.
It doesn't help you in this case, but
No.
why can't you read it that way?
Well, I would
consistent with your principles.
I would submit, my Lord, that it isn't possible to read it that way because you just look at the obligation that's imposed upon the party which is said to be a precondition, and you have to say, the question one has to ask is, how is that performed? What must be done? And one of those factors is a timescale. And it's not, and if one thinks about the utility in the context of this clause of a NCR that's provided a year later, first the question, well, what's the point of that? In the context of this provision, some kind of timeline is, we would say, necessarily wrapped up with its performance, and it's not possible to excise that out from it and say, you should look at this clause, the performance of this clause, different aspects of the performance of the clause, and some might be and others might not. That's, we would say, looking at it from the perspective of construing the contract, that wouldn't be a legitimate line of construction.
So you say that some time for performance is necessary, but the fact that the time for performance is not fixed means that it's not a condition precedent.
I do say that, yes. Or at least I militate strongly.
Yeah.
But my lord has the point.
Yeah.
I just want to show you a number of cases just to make good those points. Can I start with Bramer case,
Yeah.
which is at tab 2 of the authorities bundle. Starts at the head note because we'll find the provision there.
I'm laughing to myself, Mr. Kroll, because I'm not conscious that I've read this case since I was a law student, and the nightmare was spelling their name wrong. So my whole legal career has now come full circle because I'm being referred to this case for the first time in, I think it must be 45 years, and I don't have to worry about how to spell it.
There's a relief to my lord.
Yes.
You'll note I referred to it as the Bramer case, so I was dodging the issue as well. This decision arises in the context of a sale of goods contract on a particular form, and we're concerned here with clause 21, the prohibition clause, which starts with the word "in case of" prohibition, export, blockade, hostilities, and then it sets that out. And it says the contract should be cancelled in those events. And it says, in the event of a shipment proving impossible during the contract period by reason of any of the causes enumerated herein, sellers shall advise buyers of the reasons. Therefore, the required sellers must produce proof to justify their claim for cancellation. So, and the issue before the court, the House of Lords in that instance, was whether the obligation to advise was a condition precedent of reliance upon this clause. And I recognise they are different clauses, so there's a finite amount one gets from looking at different provisions on different terms, though I do say the word "in case of" is effectively synonymous with "if," it's as is "upon." These are all ways of identifying the world you're in. But that's, for present purposes, I just wanted to take you principally to a passage from Lord Wilberforce's speech at page 113 of the report, page 20 of the bundle. And pick it up on the right-hand column. As the clause, he says the clause is not framed as a condition precedent.
Well, he doesn't actually. He says the cancellation effected by the first sentence is not expressed to be
Yes.
conditional.
Well, he said
So the fact that it was divided into two sentences
He does.
is
Is a
of
matter-
some
it is
significance.
a matter of significance in that case. I follow that. And he goes on to say, learned counsel for the buyers invited your lordships to read clause 21 as if the words provided that. An argument which should probably support the view that without such words, the second sentence does not attain the condition status. So that's another way of Lord Wilberforce saying the words provided that would have, but the absence of it is telling in that, on the provisions of that clause. And then so that's proposition. We say that supports proposition one of my first propositions. The next point he makes is, moreover, the generality of the words without delay tells against the buyer's contention.
Where do the words without delay appear in clause 21?
Well, on the face of it, they don't.
So what's the point that Lord Wilberforce is making? Clause 21 doesn't have any, the notification provision
It doesn't have any time.
doesn't have any time.
Any time attached to it. On the face of it, the clause 21 doesn't. I agree with that. That's right. So I take that point. I take the point that on the facts of that case, it's not necessarily straightforward to identify the point he's making, albeit he is making the more general. He is making a point there that the absence of a precise period of time weighs against a clause, and we'll see other cases that to that effect. He refers to other provisions in the clause in the contract, suggesting that this is not intended to be a condition. So that's a little bit like my second point. He identifies his clause 10 and 11 and 20. Sadly, they're not in the report, so not easy to find. But again, I rely upon it for the proposition, and there are other cases I can do so for those purposes. And then a little bit further down.
Is the answer to my Lord's question to be found at the foot of the preceding column, where the words seem to have sprung from Lord Denning's judgment in Tradax in relation to what seems to possibly have been the same clause, but it's Lord Denning that says, if you're going to rely on clause 21, you have to give the advice without delay.
I'm sure that is the answer. I'm grateful.
It's been sort of
I'm grateful.
transmogrified
Yes.
actually into the clause.
Yes, my Lord Justice Lewison's point is a good one, and I recognise that. But I think the way in which my Lord's point is also would appear absolutely right, that absent a specific time period, you look back to see what Lord Denning said in the Trade Acts case, and effectively write in without delay.
Well, if it's an implied, if Lord Denning thought it was an implied term, then you do effectively write it in.
Yeah.
But that would just about the only way you can make sense of it, because otherwise he's just construing words that just simply aren't there.
Yeah, and I think that must be right.
I think this hair is set running by what he says right at the top of the left-hand column on page 113. He says the first series of questions arise in respect to clause 21. The clause will be set out in the report. So he doesn't actually tell you himself what clause he's construing. Let's hope the reporter's got it right.
So I recognise those points. I understand those. But for present purposes, and it's fair to say this case has been relied upon in subsequent decisions as giving rise to various principles, and one sees from it needing sufficient language of conditionality, no provided that being of moment. Second, if the time period, and I take my Lord's point about without delay, is to be a without delay one, that weighs against it. Second proposition is if you've got other clauses that are to be formulated differently, that may weigh against it, and these are all points that simply weigh against it. And then the point at his Roman 3, automatic and variable treatment of this runs counter to the modern approach. And that's very much my fifth point, that treating a condition, something as a condition precedent shouldn't happen in circumstances where the breach is not always going to be serious. So that's all I wanted to. It's fair to say that I'm not going to take you to it. Both Lord Salmon and Lord Russell make the point that the absence of a specific period of time weighed with them, but I don't need.
Give us the page numbers if you would.
Absolutely, it's page 126.
That's Lord Salmon.
Sorry, 128 is the reference site.
28.
Left-hand column, bottom of it. And his point is, had it been intended to be a condition, I should have expected the clause to state the precise period of time.
Right.
And something similar. So back to the without delay point from Lord Russell at page 130, 37 of the bundle, right-hand column.
Yeah.
You have the reference. The second case I'd like to take, my lords, to is the decision.
Just pausing for a moment. We have looked at clause 21, which on the face of it, as you accept, doesn't contain any time limit at all. So what Lord Salmon says is completely consistent with the clause that we have looked at. What Lord Russell says seems to hark back to what my Lord Justice Snowden pointed out, which comes from some judgment of Lord Denning possibly construing the same clause, possibly not.
I agree, I accept that. So perhaps of most significance is in the context of Lord Salmon's observation.
Yeah.
But again, I rely upon this as points of principle, though it's of course useful to the court to see how it came to arise in the particular case. I was going to take you, if I may, to the Scottish Power case,
Yes.
which is at tab 10.
This is Mr. Justice Leggett, is it?
It is, Mr. Justice. One can see the relevant provisions at 582 of the report, 355 of the bundle.
It's issue 5.
Correct, my lord, that's quite right. And one can see that Article 15.2 provided certain relief, and Article 15.4 provided a number of things which a party was required to do in order to claim that relief. Party, when claiming relief, shall. And the question was whether the items we see under clause 15.4 were conditions precedent. So that was the issue in which, the context in which Mr. Justice Leggett, as he then was, addresses this issue. There's quite a lengthy analysis of the authorities, starting at page 583 at paragraph 198 through to effectively that through to about pages to page 358 at paragraph 2003. I wasn't going to take the court through all of that. it's there if the court wishes to be assisted by it. I was going to focus on specifically a number of points, my propositions and where we see those, that being developed, in that case by Mr. Justice Leggett. Can we look at paragraph 202, please, at page 358? This is Mr. Justice Leggett setting out a passage from a decision of Mr. Justice Tears, which is also in the bundle, but we can read it here and then don't need to go back to it. And this is the observation that deals expressly with the use of the word promptly. One sees that at 202 is the provision in the Great Elephant case. So the obligation there was to promptly notify the other party in details. And Mr. Justice Tear, at paragraphs 121 to 2, you see the passage where he sets out his analysis that that's an indicator, that's a key indicator that that provision was not a condition precedent. And the rationale behind that being, it's critical if something's to be a condition precedent that you know how to comply with it and whether compliance has taken place. And for that you need, for example, clear time periods, because then you know specifically whether compliance has taken place or not, and you don't have to go down whatever your dispute resolution mechanism is before you discover whether there's been compliance or not.
There is a sense of artificiality about all this, though, isn't there? In contracts that have a set period, 5 days, 10 days, whatever it is, that may be, depending on the facts, unachievable, because it's a blanket period that applies in every situation, and sometimes it won't be, sometimes it will be. So promptly is much more generous to the person providing in this case, the NCR. So promptly works for DBS. It's better to have promptly than 5 or 10 days. But you're now saying they get an additional advantage because it's not at a condition precedent.
Well, I wouldn't put it that way, but
well, I know you wouldn't put it that way, but that would be the effect. I mean, I promptly, if you're somebody who has to give a notice under this sort of contract, promptly is better than within 5 days of such and such.
well, it's better in the sense that it makes compliance more sensitive to all the circumstances,
Yes.
which may give the party on whom that contract, that obligation falls, in this case, DBS serving a non-conformance notice, it may give them more room for manoeuvre, more time, more ability to wait until matters become clear to them. And that would be potentially advantageous to a party like DBS. I take my lord's point, but the point that's being made in the authorities, and I make, is to say, well, if you don't know, you can't be certain whether you've had compliance or not, because it depends on all the circumstances. Whether in the scenario you put to me, DBS was genuinely not in a position to give a meaningful notice until it did, or whether it was actually sitting on its hands and not doing so. That requires a factual investigation, and potentially a factual...
DBS would know.
Well, DBS might not know, because different people would have different perspectives.
Okay, it would be in DBS's hands.
Yes, but the significance here is, in order for something to be a condition precedent, so say the cases, and we say logically it's right, there needs to be clarity about what's required for performance, and expressions like promptly, without delay, and such matters don't allow for clarity, because there may be legitimate views on whether that's compliant or not, and those legitimate views means that parties don't really know whether what they must do to comply. And maybe if it's a condition precedent, and it clearly is, what DBS will do is they'll produce something that isn't much use, but at least they produce something.
But in
Whereas
fact, we know here they didn't.
Well, if it's but one needs to divorce
I
the
understand.
contractual
No, I
construction
understand.
from the facts of the
Of
case.
course, I understand that point. Anyway, you say you rely on this passage as saying that promptly is an indication, you very fairly put these are indications, is an indication it's not a condition precedent.
Then if I can just pick up Mr. Justice Leggett's reasoning now at 586, paragraph 206 of the report. And I can take this, I hope, quite quickly. In that section, he, in the context of that contract, places weight on the fact that expressions such as the failure to set out clearly what the consequences of non-compliance would be weighs against it being a condition precedent. And he makes the point that looking at the end of paragraph 206, the absence of such language seems to me to be all the more significant in the context of a detailed and elaborate contract. So that's an example of the point I was making in my proposition 1.
But again, what was going on in the Elephant case was that there was a clause in the relevant contract which introduced force majeure. That was clause 21. And then clause 21.2, that is a separate part of the clause, contained the notice provision. So again, you've got a statement of principle. You're not liable if there's force majeure. That's 21.1 in that case. And then 21.2 is you must give notice. It's in that context that Mr. Justice Tier says, well, the giving of the notice doesn't stop you from relying on force majeure.
Yes.
On failure to give the notice.
No.
And I'm not entirely clear. Yes, and what was submitted, that was a case in which notice was given. If you look at the Elephant case, paragraph 119, page 277 of our report, Bright submitted that the notice of force majeure given on the 2nd of October was neither immediate nor prompt, and therefore Vital is unable to rely on the force majeure clause. So it was not argued in that case that you didn't have to give a notice at all. The issue was, did the notice have to be prompt? And that's the issue that the judge was tackling.
Well, that's certainly the factual issue, because there was a notice, in fact, given. The issue was it non-compliant because of the timing?
Yes.
That's what he was grappling with.
Yes.
And I don't dissent from any of what I've just been put to me by my lord. As I said earlier, I identify the propositions because those propositions have been referred to in previous cases, and see, Miss Justice Leggett thinks it's worth in the Scottish Power identifying that as a relevant principle to have in mind.
Yeah.
That's why I take you to. I recognise that each one of these decisions has its own dynamic, its own provision, which may or may not mean that it has its own explanation.
Yeah.
And that's why I don't say to you that these, particularly these cases, which have quite different clauses, tell you the answer.
Yeah. Right.
And then just and then at Miss Justice Leggett still 587 paragraph 210. I'm not going to read this out, but there's a section between 210 and 213 where at 210 the judge points out that where it is unclear what has to be done, if there's a lack of clarity, it's unlikely the parties intended it to be a condition precedent. So that's if you like, the statement of principle, which I place some reliance upon. Then Mr. Justice Legger then applies that principle, both in terms of timing and in terms of substance in the paragraphs that follow at 211 to 213. And that was a case where Justice Leggett makes the point that under that paragraph 15.4, there are a number of different things which followed, all of which had to be condition precedents if the argument that there was a condition precedent was good. And he made the point that although some of them you could say you could see how you comply with some of them, it's more difficult to comply with all of them. And he was concerned by matters, and I'm not going to read this out now, but at 211 and 212, he sets out the potential issues that might arise with compliance with that clause. And makes the point that it's got to be a condition precedent for all of them. It's not good enough if it only works for some of them. And that's the point he's making at 213.
Yeah.
And then, again, I'm just going to draw your attention to this rather than go through it. He also deals with, at 215, bottom of that page and onwards, he deals with what he refers to as the strongest argument in favour, which is a contention really that if you don't comply, what's the point of it? Because in many cases there won't be any other remedy. And in the paragraphs that follow, he addresses that argument, concludes that's not a sound argument, particularly in a circumstance where the nature of the breaches can be, in some cases can be serious, in some can be trivial, and that in some cases could be said to cause prejudice that could even sound in damages, and says that the overall effect of all that means you can't look at that and simply say, well, it must have been intended to be a condition precedent because of that point. But again, there's much in there which is specific to that case, which I don't need to detain you with. But as a statement of principle, that aligns with my point 5, trivial and serious, and the need for clarity for performance.
Yeah.
So that's all I wanted to take my lords to in Scottish Power. I wanted to take my lords to the authority at tab 9, Heritage against Tullow. That is a case that arises in the circumstance of my Lord Justice Lewison purchase agreement.
Tab 9,
Tab 9.
Heritage Oil and Gas.
That's right.
Yep.
And the question in that case was whether a right to an indemnity arises and whether it was a condition precedent that notification requirements have to be fulfilled in order to have that right to an indemnity. The clauses themselves are attached as an appendix to the judgment, and one can see it at page 83 of the report, 303 of the bundle. And for present purposes, I just draw the court's attention to clause 7.4, which, as we see, Mr. Lord Justice Beatson places some emphasis on. And then 7.5, which is the clause which was said to give rise to a condition precedent, although the obligation was said only to relate to 7.5a. I just wanted to take you to the judgment of Lord Justice Beatson. The relevant passage starts at paragraph 33, page 73 of the report, 293 of the bundle. And there's paragraph 33 through to 34, and to some degree 35 are introductory comments by Lord Justice Beatson, setting out the context, setting out requirements, and making the point that my proposition 5 about the seriousness of the breach is a factor to be borne in mind in the context of conditions precedent. His reasoning, it starts at paragraph 36, page 294. And in summary, he notes the absence of the words condition precedent, but his reasoning comes in 6 lines down. You see the word first. He says the draftsman of Article 7 used words that are appropriate to create a condition precedent in Article 7.4, but not in Article 7.5. And that's an example of my second proposition. And then one sees that in paragraphs.
Sorry, your second proposition, the different formulation in the
Indeed,
different part.
indeed. And then paragraph 37, which in this report you find in the middle of paragraph 36, but there's a paragraph 7 that starts with the word secondly, and at paragraph 38.
Oh, I see, that's what that is.
It took me a while to work it out, my lord.
Yeah, I thought it might be a footnote, but it isn't. Yes, I see, it should be a paragraph break.
I think that must be right. Yeah. He sets out under the heading secondly 2 points which really relate to my fifth proposition, which is the significance of a breach being both serious or trivial, and that weighing against the clause in question being a condition precedent. I wasn't going to read through it in detail because it's the principle that matters. So I don't think we need to get anything more from the heritage case, but what one does see from that is a case where the difference in language was real and significant. Now, I wanted to move to the cases that the judge himself relied upon in construing the terms, and this relates to my third proposition, can an if provision be a condition precedent, and if so, when? I just wanted to, it's appropriate I show the court the authorities which the judge looked at. we can start by looking at the Uanda decision, which is at its authorities tab 11. This is a decision of Mr. Justice Fraser, as he then was, and it arises in a quite specific context, where the issue for him was related to the whether a call on an on-demand guarantee was valid or not. In the context of that dispute, one argument that was deployed related to whether a provision was a condition precedent. And if we see the provision itself at page 50 of the report 392 of the bundle, and it's clause 2.21. And one can see, looking at that clause, it starts with an if. And so if the subcontractor fails to complete the works, then after that we had, and if the contractor gives notice to that effect. So there's a second if inserted there, which we don't have in our clause. Then it says the contractor shall pay.
There's no then.
There is no then, but by necessary implication, I would submit the comma does the same job. If this, if that, this is the consequence, which is the same as then. And Mr. Justice Fraser deals with this briefly. I acknowledge he deals with it briefly because it was a point that came up in argument only. At paragraph 84, page 53 of the report, 395 of the of the bundle, and he makes a series of points in response to the contention that 2.21 gave rise to a condition precedent. And for present purposes, I only need you to look at halfway down his expression. Secondly, whether the notice was within a reasonable time is not even pleaded. Then he says the wording of the clause suggests that it is not such a condition precedent. Now, I don't for a moment suggest that's ratio or anything of that kind, but it's the observation of an experienced judge in this field looking at a clause of a similar kind with a conditional passage next to the notification requirement.
The generality of cases about the standard forms, building contracts at any rate, are to the effect that clauses of that type, which have otherwise been described as box-ticking clauses, are not generally conditions precedent. So I read Mr. Justice Fraser as simply repeating that general approach.
Well, that may be so, I don't know, but it is a clause which in some ways is quite similar to us in terms of the if formulation, if, and then there's a consequence.
Is that a single sentence?
It is, and I recognise that. It's a single sentence, and it is more than anything else an impression, and I recognise that.
But in fact, this whole clause, paragraph 84, is only dealing with an argument as to whether the claim had to be made within a reasonable time, which he says is a very weak argument, rejected it.
Yes.
For 2 reasons, the second of which you draw attention to. So it's actually only dealing with the time. It's dealing with the issue as to whether the words within a reasonable time create a condition precedent, not whether, for example, any of the rest of it had to be done as a condition precedent.
Well,
whether the giving of notice is a condition precedent.
Well,
And he's only dealing with a timing issue. He's only dealing with the, isn't he?
well, the issue is one of time.
Yeah, he's dealing with the promptly.
Yes, but the statement, and I don't want to elevate this to something it isn't. So, but is that the clause is not a condition precedent. It's not apt to be a condition precedent. Yes, it isn't a statement that it is apt to be a condition precedent in order to provide notice, but not timing. That isn't what my
I
lawyer
don't
is
think we're
saying.
going to get much out of this.
No, no.
It's a fallback reason. There's no analysis. It's first instance case. It's all obiter. It's the third reason that the judge gives for rejecting the argument. So I don't think we're going to.
I recognise that. But I wanted to show you that because it's one of a number of cases the judge refers to. He says there are three cases that support his position. It may be that it doesn't matter whether they do or not, because one construes every clause in its own context. But I think it's appropriate.
Any of the cases binding on us for any proposition?
No,
No, right. Well,
they're not binding on you because they're all first instance cases.
right. Well, and they're all looking at different contracts, presumably.
Well, different, but in some ways similar. Can I just show you them briefly? Because it's in my submission, the judge, in citing them as supporting his position, overstates what they say because they don't stand for what he says they stand for. And it might be that you take the view it doesn't matter, but it's right, given they're part of his reasoning, that I show you that. Can I show you the WW Gear case, which is at tab 7 of the authorities bundle? One sees the clause. This is part of the JCT standard trade contract terms. Clause is at page 229 in the headnote. In that clause we have, if the trade contractor makes a written application, and then if, as soon as construction manager is aware, and then importantly, provided always that before we get the provisions at at 1, 2, 3, and 4. And the judge's analysis of the clause starts at page 74.
In the proviso, 229 of the bundle, we have to insert a word, don't we? Provided always that the trade contractor's application shall be made as soon as and in any event not later than.
We do.
Soon as
one of-
possible, reasonable?
One of the judge's points when construing this is that there are a number of typos in it, and he approaches the construction of it with that in mind. And that's obviously right. That there are some things that there are difficulties with 4.2.1, and indeed there's much discussion of when it's appropriate to effectively rewrite because of what appears to be an error. I don't need to show you those passages, but I did want to show you the judge's reasoning for holding, as he did, that this gave rise to a condition precedent. His analysis is at page 74, paragraph 17 and 18, 240 of the bundle. So, and again, he goes through the relevant 4.21 and addresses the passages in there. He makes a reference to if clauses referred to by Mr. Justice Vinelot in the Merton case, and I will come back to that. But the passage I wanted to take you to in particular, you should in your own time read 17, is top of the next page at 241, paragraph 18. The words provided always that. The judge there says, this type of wording is often the strongest sign that parties intend there to be a condition precedent. What follows such a proviso is usually a qualification and explanation of what is required to enable the preceding requirements or entitlements to materialise. And you remember that in Bramer, provided that was something that the Lord Wilberforce thought would provide conditionality, in the absence of it, pointed otherwise. So that's one aspect of this provision that is different and significantly different to what we have in our case, where there is no provided that. But there's another element as well, because in 4.2.1, there is a reference, and we see this at the bottom at Roman D, there is reference to a 4.21.1 being a condition precedent itself, expressly identified as one. And we see over the page at 76 of the report 242, Mr. Justice Aikenhead forms the view that that was an error, and in fact, what those words should be construed as meaning, applying the Chartbrook case, as effectively saying that these requirements are a condition precedent for the entitlements under 4.21 itself. So in effect, he found that this was a condition precedent for two clear reasons. You have the words provided always that written in. And secondly, you actually have a reference to something being a condition precedent explicitly set out. And the significance of this is a case which the judge took the view, supported the proposition that an if clause was usually a condition precedent.
So
And
just a minute. Where do we get that wording? It shall be a condition precedent. That's
in the clause itself, my lord, if
oh
you
yes, got it. Yes, yes.
do you see it? It's in it's inside. Do you see it? It's 4.21.1.
Yeah, yes, I've got it.
And as the judge identifies in paragraph 18, paragraph 18D, so at the top of page 242, he makes the point that a number of things appear to have gone wrong with the drafting. And he's satisfied that in fact what that is a reference to the requirements of this, requirements being a condition precedent to entitlement under the clause at all.
Can you take your lordships to the second sentence in the paragraph, please, the one that starts essentially?
So my own friends asked me to point out to you, if we look at the passage at the top of 76, the judge in his first sentence points to obvious drafting in a second sentence, that no specific entitlement in 4.21. And then then the judge says, essentially these words are superfluous because of the drafting of the earlier parts, which is sufficient to establish the submission of a timely application of a condition precedent. And I read the judge there to be referring back to the use of the words provided always that, because that's what he says at the top beginning of paragraph 18.
Mm-hmm.
So when I addressed my lords on my third proposition, I think it was my third proposition, about if clauses, I said, ordinarily you need additional language to make clear the conditionality. Here you see the additional language, provided always that.
Is that right? Is that consistent with what he says at 17, paragraph 17A? Trigger for the operation of the clause is the making of the application. You don't ask, you don't get. No obligation to assess loss and expense unless it's been applied for. That's the whole trigger. That's what he's saying. You don't get anything unless you apply for it.
And well, this is a clause.
And that's the bit of the if then.
This is
The proviso, the provided always that, is tacked on to the if then construction. And he's quite clearly saying, as I read it in 17A, that if then means unless you ask, you don't get anything.
but the specific requirements that 1C set out. The way in which you must do it
Yes,
is a provided always.
yes.
And this is a clause that the if is if you've made a written application. If you were eliding that with our clause, it would be if a milestone has not been
Well,
achieved.
That's the question we have to decide.
And to what extent that one if is also, and I recognise that, but it's useful. I showed you this, my lords, because the judge placed emphasis on it, and it's a there's a risk he put the point. We would say put the point a little high based on that authority. It's important to have, and the Styria case, the previous tab 6.
Just to be clear, you've got a clause there where the first bit of it is the condition precedent. You've got to make an application because if you don't ask, you don't get. But the timing provision which is in the same clause, is not a condition precedent.
No, I think he says it
No.
is. I think he says it is.
He said it is.
It is.
Yeah.
So he's okay.
So just making the application and the timely making of the application, that's what he says at 19, first sentence, is a precondition. Although he doesn't tell you what he's going to put in the timetable after as soon as. We're still left with as soon as and in any event.
No, it's perhaps worth just
As soon as what?
as soon as and in any event, not later though. So you do have a backstop period.
We do. What? As soon as what?
That's left unclear in that case.
So the closest we get is where the judge uses the word timely.
That's as close as we get. But quite what that means in that context, I don't know. And of course, the individual decisions will, to some degree, turn on their own facts of construction, and that's I follow that. But I think it's important for me to make the point that if at the start of these provisions just tells you the world you're operating in, the context in which the clause takes effect. It can be a if you've made an application. It can be a if somebody's in breach of contract.
Yeah.
It doesn't, and where the if that bites is not something that has to be done by somebody, or it's been done, failure to do something like counterparty, that if is fulfilled in that event. And as my lord says, the question is, does that if then become an additional if when it comes to the obligation to notify?
Yeah.
And the point I make is, my point, no, provided that, no, there isn't the clarity one would see, one would identify in that context. Just let me take the Styria case quickly, because that's the other case my learned friend relies upon. The judge relied upon. It's a tab 6. We can see the clause itself in the on page 157. And what it sees is the subcontractor shall complete the works if by reason of any circumstance which entitles the contractor to an extension of time, or by reason of any breach by the contractor, he shall be delayed. Then in any such case, provided, a word I place emphasis, the subcontractor shall have given a reasonable period of notice. So the if here is a little bit like our if. It's if you're in a world where there may be a prima facie entitlement. It then says, and here you've got a notice provision with the word provided attached to it. And as we see from the reasoning in this judgment, it is those words, the provided, that are said to make all the difference.
Yeah.
And just for you note, we see that's the argument that was deployed as recorded by the judge, page 202, 182 of the bundle, paragraphs 83 to 84. So the argument was it's the provided that makes a difference.
Sorry, which page?
Sorry, page of the judgment, of the report 202, paragraph 83 and 84 might be. Do you have that, my lord?
83 and 84.
Yes. 182 of the bundle.
Yeah.
That's where he deals with it, and at 84 he records the argument that provided that imposes an unqualified condition precedent, and the judge's conclusion over the page at paragraph 90 is that it is those words, provided that the subcontractor shall have given, are the things, I'm not going to read the whole paragraph to you, but the paragraph, that is what's decisive in the judge's conclusion, that the giving of notice was a condition precedent.
Yeah. Even though there was no fixed time limit.
In that case, there wasn't, you're quite right, my lord, that is an instance where there is no fixed time limit and not even a backstop. And then in some ways, I don't need, so the provided that is all important, we don't have it here unless one writes it in. And that's the very thing in my submission that the court mustn't do, because the parties are required to use their language clearly.
Yeah.
And then
you don't quarrel with any of the judge's reasoning in this section of his judgment, do you?
well, that might depend on precisely what my lord means by that.
Well, as I put to you, the judge has said that there is a condition precedent which disentitles the subcontractor to the extension if he is not given notice, quote, within a reasonable period, unquote. The judge says that is a condition precedent, despite the reference to within a reasonable period. Do you accept that that's correct on the facts of the particular case?
Well, I have no reason to say that the judge is wrong on the facts of a particular case, because, back to a point I made earlier, the absence of a fixed time period is a factor.
Right.
It's not decisive, it doesn't preclude. I don't think the authorities would allow me to submit otherwise. And the only other case that the judge relied upon was the decision of Mr. Justice Vinelet in the London Borough Merton case. That's at tab 3. Page 56 of the authorities bundle is where the judgment starts. The relevant clauses, that's right to say this is an appeal from an arbitrator. It was, the arbitrator decided 15 separate preliminary issues, of which we are concerned with 2 sets of those issues, because they may be relevant to an understanding of Mr. Justice Vinelet's approach to clauses of this kind, and the judge placed reliance on that. The clauses in question are at page 74.
74 of the report.
74, I'm sorry, my lord, of the bundle. Of the bundle.
Clause 24 is this?
24 is at the bottom. Can I invite my lords to look at clause 23 as well? Clause 23 is a separate provision. So upon it becoming apparent, the contractor shall give written notice, or forthwith in that case, give written notice and there was a separate issue in the arbitrator decided as to whether that gave rise, the notice requirement in that clause gave rise to a condition precedent, and the arbitrator said no, and the judge agreed. And so far as we can see, that is the only place where he expressly addresses a condition precedent argument. One sees the judge's reasoning, and being dealt with at page 77 of the bundle, 89 of the report, under the so-called issue 14. This is not the passage that the Justice Constable referred to, but it is the only issue which is expressly a condition precedent issue. And under clause 23, both the arbitrator and the judge took the view that the giving of notice was not a condition precedent. As we say, in many ways, upon is, again, synonymous with if. It tells you the world you're in. So upon it becoming apparent, if you really did it this way, upon the giving of notice, if in the opinion you get the relief. But the view that Mr. Justice Weinlock took is that there was, it was not a condition precedent, and one finds that at pages 77 to 78, pages 89 to 90 of the report. And the reason why I show you that is that in the passage that the Mr. Justice Constable referred to, which comes later, Mr. Justice Constable takes the view that clauses which are in many ways quite similar are being held by Mr. Justice Weinlock to be conditions precedent. And in fact, we say that's not a fair reading of what Mr. Justice Weinlock was doing.
Which is the paragraph in the judgment.
We find that, we find the paragraph in the judgment is at the bottom of page 83, and it arises in relation to a different set of issues, preliminary issues 7, 8 and 9, which start at page 82.
Paragraph, sorry.
Sorry, it's page 82 in the bundle, 94 in the report. It's this report predates paragraphs, I'm afraid. But we see the heading.
Sorry, I was asking which is the paragraph in the judgment?
Sorry, I apologise.
That's to say Mr. Justice Constable's judgment, in which he refers to Merton and Lee.
67, 68.
I'm grateful, my lord. So, just looking to see what Mr. Justice Weinlock was addressing in preliminary issues 7, 8 and 9. He was addressing in that context whether an adequate notice had been provided. There's no dispute a notice had been provided, but did it have the sufficient detail to operate as a notice? And such that the architect was then bound to go on and assess matters. And it's in that context he makes the observation at the bottom of page 83 in the bundle, 95 in the report. Mr. Justice Weinlock says the common features of subclauses 24.1 and 11.6 are they are both if provisions. And that's the
Just give me the paragraph reference of the judge's judgment.
The judge's judgment, paragraph 67 and 68, page 84 of tab 7.
67, he sets out the
Yeah.
clause. 68, he refers to the clause, but then he goes straight into Mr. Justice Aikenhead dealing with in the case you just showed us.
Yes, that's right.
And then the only other reference that I can find to Merton is at paragraph 93, on page 91, which is to do with promptly.
That's correct, my lord. I think those are the places where.
I'm sure it's my fault. I don't quite understand where you say the judge over relied on Merton and Leach.
Well, he relies upon.
It doesn't seem very key to the judge's conclusions.
Well, the judge, refers more fully, I agree, to W.W. Gear construction. But in that case, Mr. Justice Aikenhead does specifically extract the passage I was about to show you, which talks about common features are these are if provisions, and says that's illuminating. And
Justice Vinelot's simply wrong, isn't he? Because he's already held that 24.1 does not require a written application by the contractor.
no, in the earlier provisions,
Yes.
he was looking at clause 23, my lord.
Oh,
So he's dealing with different.
23, yes. Oh, I see. Yes, I follow.
So he was here looking
Yeah.
at a different clause
Yeah.
and a slightly different question.
And that's page of the report of Merton and Leach.
Page 86. Yes, so clause 23 does not require a written application. 24 does. I see.
But and the issue on 24 was all to do with the adequacy of the
All
application.
to do with.
The adequacy of it, whether it was full or not,
Yeah.
and whether the clause required it to be like certain amounts of detail to which the arbitrator said it's not required, it's enough that any application is made really, and Miss Justice Vinelot agreed with that.
Yes.
So it's important, we would say, to understand that insofar as, and I take my Lord Justice Coulson's point that it may be that Miss Justice Constable placed limited reliance upon Merton, but insofar as any reliance is placed upon it, and insofar as you may be assisted by it, and you may take the view you're not assisted either way, one needs to understand what the court was deciding in that case, and note the fact that in that case, this was not being approached under the label conditions precedent and all the analysis and case law that one sees elsewhere in the cases which are not considered in that case. So there's a limit to what one can sensibly get from what Miss Justice Vinelot said. And in fairness to Miss Justice Aikenhead, who does refer to this in the W.W. Gear case, it's clear in my submission that his reasoning is not based on anything we see in the Merton case, but actually on the specific language of the clause in front of him.
No. I mean, the seismic effect of Merton and Leach was all about implied terms.
Indeed. That's its significance. That's all I wanted to say in relation to authorities. I now wish to draw the threads together and indicate what we say. I've covered much of this ground already, so I hope to be able to deal with it quite quickly, but the court may have questions. We say clause 6.1 it is not a condition precedent because the language is not precise enough. No use of condition precedent, provided always that, or even subject to, of the kind one sees not just in other provisions, but in the provisions of this contract. The most that can be said is that the clause begins with an if. But that does not answer the question whether that if applies not only to the opening passage, that is to say, test failure or failure to meet milestone, whether it applies also to the requirement to provide an exception report. There is no second if, as we see in other clauses. There are no express words of conditionality attached to the requirement to serve an exception report. If one looks at the language of the clause, what precedes the obligation to serve an exception report is a comma. Put at its lowest, the comma is as consistent with inserting, if you want, looking to find a preposition that belongs, a then. If this, then you must do that. Or it's a consequence of the failure of milestone, but it is not of itself subject to the conditionality. There's no.
If there was and instead of a comma, then it would be, wouldn't there? You want to insert then. Suppose you insert and instead.
I'm not suggesting, my lord, I don't want to insert anything. I'm
No.
pointing out what's not there.
No, I
If there
follow.
was an and, the point against me would be stronger.
Yeah.
It would be easier to say the conditionality is applicable to both passages. I would recognise that. The absence of the and is itself, we would say, significant. And all of that, so, and the then at the end of the paragraph in our submission doesn't answer the question that this court has to decide. It's clear that there is, at the end of the paragraph, it says, in this event, effectively, you will have these options, but it doesn't define the condition that has to be satisfied, and that all depends upon whether one's attaching conditionality to the obligation to provide an exception report or not. And if you aren't, there's no reason why the then needs to sit with it. And that's really that's the point on the language itself. But the second point, which is we say, is in a world where the language is itself unclear, all the more telling, is the fact that these parties, when they intend to create a condition precedent, know how to do it. They have a formulation, they have formed words, and they've used a very different formulation in those circumstances. And the absence of that formulation, as it was in heritage, particularly in a space where there isn't sufficient clarity of language in 6.1, we say is a very strong indicator that the obligation to provide an exception report is not a condition precedent. And it is in our submission it may be of significance that no coherent explanation for why there should be a difference, but nevertheless it should be subject to condition precedent, has ever been put forward. But ultimately the test is objective, so that may not really matter. And the difference is not simply, we would say, the use of the different formula one sees in 5.6, but also the clarity about the obligations under 5.1, 5.2 and 5.3, particularly 5.2 and 5.3, which is quite different, we say, to the use of the word promptly, and my lords have that point. Which is really my next point is that point, the use of the word promptly in a context of a clause which is otherwise unclear is yet another factor that weighs against it being a condition precedent. And we do say that it's relevant in this context that, and we spent some time on this earlier this morning, it's relevant in this context that there are circumstances in which an exception report is going to be effectively telling the contractor what it already knows. And in those circumstances, it's hard to see why a clause of that kind would have been objectively intended to be a condition precedent. And it is relevant that those circumstances arise, and we do say as a matter of analysis, it's either got to be condition precedent in all circumstances or in none. You can't have some or the other. And that aligns with the point about breach being sometimes trivial, sometimes being serious, and that's a factor against.
You didn't, I don't think you meant exception report in that, did you?
I meant, you're quite right, my lord. Non-conformance report is what I meant. You're quite right, I apologise. And in the same vein in relation to uncertainty of what's required for performance, in the context of clause 5, where the contractor will be providing information to us within specified time periods and will be providing information which may well be highly relevant to what we may wish to put in a non-conformance report, that creates uncertainty potentially about when it is promptly really means. Does it mean we're entitled to wait? Does it mean we have to act immediately? That uncertainty militates against it being a condition precedent. It also creates a potential uncertainty as to just what our non-conformance report really has to say in circumstances where much of it may already be being said to us or may have been said to us. And that militates against it being a condition precedent. I just wanted to show you a passage in the supplemental bundle.
Well, before we do that,
Yes.
just how long are you going to be in the rest of your submissions? So I see it is now 1 o'clock.
Yes, you're quite right, my lord. I'm going to be, I would hope, the thing that may take up a little bit of time is looking at the document. Apart from that, I will be short. If I'm 10 minutes maximum, I expect.
Including,
summarising matters.
including time for looking at the document.
I hope so, but I'm always wary as counsel to promise things which I may not deliver.
Minutes, then carry on. If you're going to be longer, then I think we'll take a break now and resume.
Well, I can't promise I'll be as short as 5 minutes, so.
2 o'clock.
Court rise in favour.